My name is Dan Goldberg, and I welcome you to Toronto. For those of you outside of Toronto, the city where our municipal politics serves as your late-night entertainment. I am joined today by Gary Diebele and Mindy Mitnick, both of whom are from Minnesota. So welcome to Toronto again. And my talk this morning will focus on the issue of the rights of grandparents to have access to their grandchildren over the objection of parents. And this issue, I believe, is going to be far more prevalent in courts as baby boomers become grandparents in increasing numbers. So let me provide you with one definition of grandparents: the people who think your children are wonderful, even though they're sure you're not raising them right. And while the issue of grandparent-grandchild access is not new, it gained widespread publicity across North America when 14 years ago the U.S. Supreme Court heard the case of Troxell and Granville. So during Tommy Granville and Brad Troxell's relationship, which ended in 91, they had two daughters, 2 and 4 years of age at the time of the trial. And until Brad's suicide in 93, Brad's parents, Jennifer and Gary Troxell, and they're pictured on the screen, they had regularly seen their granddaughters on weekends. However, after Brad's suicide, Granville, the mother, wanted to reduce their visitation time to one short visit a month. And the Troxells sued for the right to visit their grandchildren under a section of the revised Code of Washington, which permits any person to petition for visitation rights at any time and authorizes state superior courts to grant such rights whenever visitation may serve a child's best interest. Now, Granville did not oppose the petition outright, but she did oppose the amount of visitation time sought by the Troxells. And subsequently, a Washington Superior Court ordered more visitation than Granville would accept, and she successfully appealed, and the Washington Court of Appeals reversed the lower court's decision by holding that non-parents lack standing to sue under the statute. So in affirming, the Washington Supreme Court ruled that the statute unconstitutionally interfered with their parents' rights to rear their children. And this decision, again, was affirmed by the U.S. Supreme Court by Justice Sandra Day O'Connor. And maybe you can let everyone know, because I don't know, but in Canada, the Supreme Court of Canada rarely hears family law matters. I think it's even more rare in the United States for a family law case to surface or rise to the Supreme Court of the United States. So Sandra Day O'Connor, writing on behalf of the majority, said that the raising of a child is one of the most fundamental of all protected liberties. Because of this, the state must prove the existence of a compelling interest for the statute. And Justice O'Connor pointed out two important issues. The first, the statute did not require the court to afford any special weight to the parent's decisions regarding the child. And second, there was no determination that the parent was an unfit guardian of the child. And this latter point was particularly important because there's a presumption, both in Canada and the United States, that fit parents act in the best interests of their children. So in 2001, less than 1 year after Troxell was decided by the U.S. Supreme Court, the case of Chapman and Chapman came before the Ontario Court of Appeal. And Chapman involved an intact family with two children who at the time of the trial were 8 and almost 10 years of age. And the children's grandmother, Esther Chapman, sought access to them. The parents, Larry and Monica Chapman, and the grandmother had a very poor relationship, as the parents believed that Esther was a very negative influence on them and their two children. But nevertheless, the parents acknowledged that maybe there would be some benefit to the children having some contact with extended family. And the dispute before the trial judge was not whether visitation was going to take place, but the degree or the frequency of the visitation. And Larry and Monica's position, Chapman's position, was they were fit, competent, and loving parents who believed that they, not Esther Chapman, and not the courts, should determine how often their children should have access to their grandmother. So accordingly, the parents appealed the trial judge's decision, which provided the grandmother with more access than the Chapmans were prepared to provide. And Justice Rosalie Abella, who was then on the Ontario Court of Appeal, who now sits on the Supreme Court of Canada, writing for a unanimous Court of Appeal, stated that in the absence of any evidence that the parents are behaving in a way which demonstrates an inability to act in accordance with the best interests of their children, their right to make decisions and judgments on their children's behalf should be respected, including decisions about whom they see, how often, and under what circumstances they see them. Larry and Monica Chapman, not Esther Chapman, are responsible for the welfare of the children. They alone have this legal duty. Any duty to create such a relationship lies with the children's parents. The failure to do so does not warrant judicial intervention, especially in circumstances such as these, where the immediate family is functioning well and the children's best interests are being assiduously nurtured by dedicated parents. So just as the U.S. Supreme Court held in Troxel, the Ontario Court of Appeal also held that fit and competent parents are presumed to act in the best interests of their children. As such, the parents should decide with whom they wish their children to interact, not the courts and not grandparents. There is a substantial body of social science research regarding the effects of divorce on children, as we all know. This research is focused largely on the role divorcing parents play in their children's lives. There is very, very little research on the role that grandparents play in the lives of grandchildren. The inherent vagueness of the best interest of the child test also makes it difficult to know what factors to evaluate and how to evaluate them. As a result, popular culture and mythology fill the void. Popular culture has a very sentimental and nostalgic notion of the grandparent-grandchild relationship. Some of these parents reflect what most of us would like to believe that relationship is like. Warm, loving, giving, and cuddling grandparents. Anybody recognize this person? Welcome to the 44th President of the United States. Again, this is what we want to believe this relationship to be. Judges, many of whom are themselves grandparents, probably also want to believe this notion of the role of grandparents. Many of you here today are now grandparents. Could you raise your hand if you're a grandparent? Okay. And I'm sure you all recall your lives as grandchildren. And a few of you here today, this is going to be a small subset of people, a few of you here today may even be both a grandparent and a grandchild of a living grandparent. Anybody in that category? Fantastic. Wow. So let me, there's a whole other side to the story of grandparents and grandchildren and their relationship. It's obviously not always the way that popular culture portrays it. The relationship between grandparents and grandchildren can be negative. When it is negative, it's often so because of the poor relationship that exists between the parents and the grandparents. Let me show you a brief segment from a television show which reflects the tension between parents and grandparents over who makes decisions concerning the child. Oops, I'm sorry. I'm going to go back a second before I get to that video. There's also these cute little vignettes that I think we also want to associate with grandchildren. We talked about grandparents in the pictures cuddling their grandchildren. This is some grandchildren talking about grandparents. Being a grandpa is like being president of your family. It's the top job. I have a grandma from France. She speaks English and French. Grandparents can be smart, even at their age. Grandpas and grandmas are the ones who always love you and never yell no matter how many dumb things you do. The one thing I don't like about my grandma is they have this photo album with everything in it from when I was a very little baby. One of them is when I don't have anything on, and I wish she would take it out of there so nobody would see me naked without any clothes. But she says it's too cute for words. It's not so great if you go over there on the night they have liver. You have to be very careful with grandparents. They get sick easy, and they can't eat a lot of things, but it's worth all the trouble to have them. My grandpa uses a lot of bad words, and my grandma gets very upset, and she says, not around the children, but it's okay because I know all the words anyway. You never know what kind you will get. I guess I was just lucky. So, now let me take you to this episode a little clip of a show which will tell you that despite the pictures and these cute vignettes from children, things aren't always as they appear, and they can be negative.
Dad, you're going to haul us into court over this?
We're his parents. We know what's best for him.
No one's saying that you don't have a right to send Sean to a boarding school, but my clients...
Sorry. Raise the volume.
Dad, you're going to haul us into court over this?
We're his parents. We know what's best for him.
No one's saying that you don't have a right to send Sean to a boarding school, but my clients also have a right to see their grandchild.
No.
Actually, they don't have that right.
Listen, we're a part of Sean's life, too. When he was a baby, we practically raised him while you two were so busy working.
We're less than an hour away from appearing before a judge. I was hoping we could work something out here.
It's been 2 months. We just want to visit him. I mean, can't you at least tell us where the school is?
I'm sorry, Mom, no.
They just want to see his dorm, meet his roommate. You were such a close family. There has to be some kind of compromise here.
This is hard for everybody. My clients are just looking out for Sean. His behavior has continued to deteriorate.
He's a 15-year-old kid. Of course he misbehaves once.
Trouble, Dad. He needs structure. He needs more discipline.
That's the last thing he needs. I think if I could just get him up to the mountains one more time.
This is exactly why we don't let you see him. We're his parents. We make the decisions, and you have never respected that.
Jack.
No, forget it. Sean's out of the country. You can see him when he gets home in 18 months.
18
months?
We've never gone a week without seeing him.
Maybe that's the problem.
Thanks. I apologize for the volume. Hopefully, did you hear it? Okay. So each of the 50 American states has some form of statute permitting non-parent, including grandparent access. In Canada, the Grey Lobby has had some success in moving several provinces toward enacting specific legislation regarding grandparent access. Quebec's civil code is unique in Canada in that it contains a presumption of protecting an existing grandparent-grandchild relationship. And it makes it clear that where there's a dispute, deference will not necessarily be accorded to a parent's decision. So it talks about the interference, you can see, without grieving, interfere with personal relations between the child and his grandmother. Interfere means that there is an existing relationship. That some provinces' legislation and the Federal Divorce Act contain no specific language regarding grandparent visitation is in large measure attributable to the fact that the existing language of the relevant statutes already permit such applications to be made. So, for example, Section 21, which is at the top of the screen, of the Ontario Children's Law Reform Act states that a parent of a child or any other person may apply to a court for an order respecting custody of or access to a child. So in Ontario, when the court is determining whether or not access is in the best interest of a child, it's also statutorily directed to consider whether access to the child by blood relatives, which in most cases would be grandparents, would include grandparents, is in the child's best interests. And the Divorce Act, which is federal legislation, allows, with permission of the court, leave of the court, standing for individuals other than a spouse to apply for custody of or access to a child. So again, it would potentially include grandparents. So while the case law is not entirely consistent, the prevailing judicial position is that for grandparents to be considered any other person having a right to apply for access, they must have, as a preliminary step, they must establish that they already have a close relationship to a child at the time of the application. And grandparents must demonstrate that they're not using the application to either create or establish a relationship. So given that the right of access is the right of the child, then it's appropriate where ascertainable that the views and preferences of the child regarding grandparent access be ascertained. And the Ontario Children's Law Reform Act provides for such input when the court is determining whether access is in the best interest of a child. The views and preferences of the child, if they can be ascertained in 24(2)(b). In Ontario, if court ordered, counsel for a child may be provided by the Office of the Children's Lawyer, where I work, in a grandparent access case. and counsel will normally place the child's views and preferences in context before the court, along with other relevant evidence. So in the years immediately following the Ontario Court of Appeals decision in Chapman, courts struggled with the divergent approaches to parental autonomy. Divergent approaches of one, parental autonomy, the right of parents to determine who should have contact with their children, versus the direct application of the best interest test, which often led to pro-contact orders being made. In 2005, the Giusanti di Chiara case positively helped to crystallize the manner in which grandparent and grandchild access cases should be determined. In this case, the mother tragically died in a car accident in which the father was driving her, their child, and members of the mother's extended family. And following the mother's death, the child lived with a father who eventually became distant from the mother's family before mother's very large extended family. And the child had ordinarily, during the marriage, had daily contact with the mother's extended family. And the father, again, the father became distant. He provided less access than the grandparents wanted. The grandparents sued, and the father did not oppose access, but he wanted to decide the frequency and nature of it. And the trial judge stated that Chapman stood for the principle that courts should generally defer to a parent's decision about grandparent access, unless, the trial judge then added, all three of the following questions are answered affirmatively. Does a positive grandparent-grandchild relationship already exist? Has the parent's decision imperiled the positive grandparent-grandchild relationship? And three, has the parent acted arbitrarily? Again, all three of these questions have to be answered in the affirmative. In Giusanti, the court found that, in fact, all three of the parts of this test were answered affirmatively, and then applying the best interest test, ordered access on alternate Sundays to the maternal grandfather, where the mother's extended family would gather each week. And many courts have applied the Giusanti test to cases before them. However, again, given the vagueness of the best interest of the child test, the state of the law in Canada, and I suspect in other jurisdictions in this area, is still not consistent. My own feeling about the best interest test is its virtues are that it's vague and flexible, and its failings are that it's vague and flexible. But I digress. Generally speaking, the courts historically often treated claims for access by grandparents differently when the family is intact as opposed to single-parent families. And I suggest that it's far more useful to look at the stability of the family unit rather than its composition. And having said this, though, with intact families, the courts usually accord greater weight to the wishes of custodial parents, and courts proceed with caution not to unduly interfere with the parents' inherent right to determine the course of their child's upbringing. The more typical grandparent access claim occurs when the parents no longer cohabit, or one of them is deceased or is mentally ill. In these instances, the courts appear to be more willing to be pro-contact and to provide access to grandparents, particularly in those situations when there's no contact between the non-custodial parent and the children, and basically the court hopes to provide the children with the purported benefits of extended family. And this is particularly meaningful if, say, the non-custodial parent's family is from a different culture, and it would be important for that child to know the non-custodial parent's culture. Again, the case law demonstrates that where court orders access, it's usually to maintain an existing relationship and not to create or establish one. There's an emerging and significant body of case law in Canada where the determination of a single parent regarding access is respected. Unless a parent's decision is based on unreasonable concerns, the court's tendency is increasingly to respect the autonomy of that parent's decision. And judges frequently reiterate their recognition that parents, including single parents, are presumed to act in the best interest of their children. Thus, single parents now are accorded far more rights to determine with whom their children will associate. This is especially so, of of course, when there's acrimony between the grandparents and the parent. Where grandparents have served as custodial parents for the child for a significant period of time or stood in loco parentis to that child, they may successfully argue, as in the Ontario case of Duchesne and Perry, that they served as a psychological parent to the child, and disruption of this relationship would be psychologically damaging to the child. This is in part really a harm-based analysis, and it's important to note that these types of cases differ from a visiting relationship between a grandparent and a grandchild. The distinction may represent something between a relationship which is beneficial to a child and a child's welfare, to a relationship which is necessary for the child's welfare. Except for the circumstance of the non-parent standing in loco parentis to a child, many courts do not view parents and non-parents on the same legal plane. The Ontario Children's Law Reform Act gives some effect to this proposition by stating that only the father and the mother of a child have equal entitlement to custody of their child. The Ontario case of Moorcraft effectively held that while the best interest must remain paramount, the considerations revolving around the issues of access to third parties, including blood relatives, are far different from those involving natural parents. There is no automatic right of access to third parties. In a relocation dispute between parents, the Supreme Court of Canada in Gordon and Gertz has held that both parents bear an evidentiary burden to demonstrate where the best interests of the children lie. However, in a prominent grandparent access case, the British Columbia Court of Appeal held that the onus was on the grandmother, not the mother, to show that the proposed access was in the child's best interests. And grandparents also have the burden of proof, again, of affirmatively answering all three questions in the Giansante and DiChiara test. Now, Article 611 of the Quebec Civil Code is a clear expression of a legislature reversing the burden of proof and placing it squarely on the parent. In Quebec, the onus is placed upon a parent to demonstrate that there exists a grave reason why access to their child by a grandparent should not take place. So in the 19 years since Gordon and Gertz was decided by the Supreme Court of Canada, apart from Quebec, most of the case law in Canada holds that the burden of proof in grandparents' access case is on grandparents. This is another manifestation of judicial recognition that the legal claims of non-parents and parents should not be viewed as being on the same legal plane. As we all know, the best interest of the child test governs in child custody and visitation disputes in Canada and the U.S. However, if it is accepted that third-party access claims cannot be viewed on the same legal plane as parental claims, then the question has to be raised as to the appropriateness of using the best interest standard in the same fashion in which it's presently being applied. In the U.S., academics have observed that the public policy concerns should override consideration of grandparent visitation requests based solely on an allegation that it's in the best interest of the child. They and much of the prevailing American case law state that short of preventing harm to the child, the best interest of the child standard is insufficient to serve as a compelling state interest, overruling a parent's fundamental right to make decisions about their own child. To do otherwise, they claim, is to invade the private realm of family life and undermine parental autonomy. In Canada, many courts have also held that absent abuse or neglect, parents have, to a great extent, significant and controlling rights to rear their children without outside intervention. Canadian courts have, in some instances, explicitly used, in the context of the statutory best interest standard, a harm-based analysis when determining the appropriateness of grandparent-grandchild access. The courts have looked at the harm to a child, both in the context of the direct loss of contact with the grandparents, as well as the adverse impact upon the nuclear family in the event access is ordered. And applying a harm-based component to the best interest test in non-parent access claims recognizes the reality, again, that these cases need to be approached differently. Many judges in both in Canada and the United States hold nostalgic views about the grandparent-grandchild relationship, as I mentioned earlier. As a result, they're frequently tempted to allow non-parents access claims to succeed because, in their view, the child will benefit in some way that will better their lives. In Daly and Daly, a clearly non-nostalgic judge of the Nova Scotia Family Court denied access to grandparents, even where he considered that access to be a possible benefit to a child. Here the judge stated that it is not the role of the court to infringe on the inherent right of parents to make child-rearing decisions simply because a judge believes that a better and alternative decision could be made. Children spend a considerable amount of time in school. Apart from school, they may be involved in extracurricular activities, such as hockey in Canada, or dance. Just as we all do, children have a finite amount of time left to spend with family members and friends. So what if their parents are separated and both sets of grandparents want access independent of the parents, just like they did when the parents were married? What if there's another close relative that wants to continue access? What if a teenager wants to spend his or her weekend with friends? Or what if the child has a needed part-time job? Children can only be pulled in so many directions until their best interests become compromised on the altar of trying to placate various family members, all of whom may be very well-intentioned. Perhaps the approach which may be most appropriate is a simple type of bifurcated hearing where there must be an initial showing of actual or possible harm to a child, which would arise from the termination of access to a grandparent. If this harm could be established on the evidence, then the court should move to the second stage of the hearing to determine what, if any, access would be in the best interest of the child. If no harm is established at the initial stage, then I'd suggest that the court should not intrude any further into the decision-making authority of the parents and into the private realm of their family life. And this approach has been applied by 2 Canadian courts in the last few years. So as baby boomers become grandparents themselves in increasing numbers, and they occupy seats of power in legislatures and represent a great lobby of baby boomers and older grandparents, is it any wonder there are any pressures to amend existing legislation to better favor grandparents? It should also be noted that polls regularly show that people vote in greater proportion to the rest of the population, older people vote in greater proportion to the rest of the population, which is a fact clearly not lost on politicians north or south of the border. Last year, a bill was introduced into the Ontario legislature by one member of each of the 3 major parties, Ontario parties, to amend the Ontario Children's Law Reform Act by explicitly including grandparents in the sections dealing with custody and access. And most significantly, the proposed amendment sought to have the court consider parents and grandparents as being on the same legal plane. And this legislation was not enacted into law prior to the legislature rising for a provincial election, which is actually going to happen 2 weeks from today. So I would like to reiterate that the role of non-parents and particularly grandparents, the role that they can play in children's lives can often be very positive and very enriching. However, the reality of professionals working in the family justice system is that many families do not fit the Norman Rockwell image that is popularly held of grandparents. As family life has evolved, stereotypical conceptions of family are really not always reflective of reality. That some situations of access by a grandparent to a grandchild have entered the courtroom clearly suggests that the traditional notion of one big happy family has to be examined clearly and challenged in individual cases. We can't just rely on sentimental, nostalgic notions. And more extensive research really needs to be done into contemporary grandparenting roles in general and into high conflict access situations as well involving grandparents. It's likely that in appropriate cases, mediation can assist grandparents and parents to come together to work towards an arrangement which allows visitation, which serves the grandchildren's interest, and in terms of maintaining an existing relationship, but also preserves the parents' primary role in their children's lives. In my view, Justice Sandra Day O'Connor in Troxel correctly summarized the general approach that judges ought to assume in high-conflict grandchild cases. In an ideal world, parents might always seek to cultivate the bonds between grandparents and their grandchildren. Needless to say, however, our world is far from perfect, and in it, the decision whether such an intergenerational relationship would be beneficial in any specific case is for the parent to make in the first instance. Last comment. Let me conclude by quoting the concerns of one group of researchers, which has particular relevance, I think, in many circumstances, to court-ordered grandparent visitation. While children doubtlessly benefit from the various adults contributing to their development, these relationships are meaningful as they occur naturally, not as they are judicially enforced. Legalizing the ties that bind may in the end undermine the relationships nurturing the children we seek to assist. Thank you for your time, and now Gary is going to speak. And I hope the grandparents out there will not shoot any barbs towards me. I love grandparents. I grew up with a grandparent.
Well, while we're getting that set up, I'll give you a few introductory comments. I'm going to talk about developments in the United States in particular with regard to not only grandparent visitation, but the broader topic of third-party custody and visitation. And one of the things I want to circulate is I wrote a law review article back in 2007 that was a close analysis of the Troxel case, as well as some litigation that we had going on in Minnesota. In 2000, 2001, 2002, I had a contested third-party custody case which involved maternal aunt and uncle against a biological father. That was going on at the same time Troxel was being handled by our U.S. Supreme Court, and at the same time we in Minnesota were passing a new statute, a new comprehensive third-party custody statute. So we had our Minnesota Supreme Court, our Minnesota legislature, and the U.S. Supreme Court all looking at this issue. I reread the article. It's from 2007 on the plane up yesterday, and it's still current. So I'm going to hand it out to you. AFCC limits how much paper we can give to you all. So what I'm going to do is the article is here, and if you're interested in it, I can email you an electronic copy of it. So put your name and address on this, and I'll be happy to send that when I get back home. Well, my practice back in Minnesota is primarily a family law practice, but I do a lot of adoption work, a lot of third-party custody work, third-party visitation work, and a lot of assisted reproduction. And so I've come to, in part of my practice, basically see a lot of different types of third-party arrangements that come up in a variety of contexts. And so what I want to do is give you a little bit of background about what the trends are in the United States on this area, and then also comment a little bit about the broader impact of our family law practices as a result of what's going on with these third-party cases. Let me get my PowerPoint notes here, just a second. I do, by the way, have an outline in the materials as well. My PowerPoint follows along on the outline, so if you're looking at the outline, you'll be able to track along with what I'm talking about. Okay, well, for those of you who are family law attorneys, and I know there are a number of you in the room, I'm guessing that you have seen probably the same thing that I have seen, which is kind of an explosion of third-party custody issues in our practices. And I think one of the reasons for this is that there's a lot of different changes going on with the family in general. And I think when you have a situation like that, you're seeing a lot of families that are in need with mental health issues, chemical dependency issues. A lot of children are being born outside of a marital relationship. And so there's a situation where parents are needing a lot of help raising their children. And there's growing concerns about a lot of parents' ability to function. And as a result of that, you're going to see a lot of increase of people coming in looking for other caretakers for their children. And so I think you'll see that explosion as a result of that. The other thing that I know that I've seen in Minnesota, and I think this is common probably across the United States and Canada and other countries, is that more and more of these cases are coming in with unrepresented parties. I know AFCC has had presentations over the years about the explosion of pro se representation, and that's a huge issue in these third-party cases as well. And I think now third-party custody, while it used to be, and third-party visitation used to be sort of a niche practice for family law attorneys, those of us who specialized in maybe adoption or other things where we were doing family building outside of divorce cases, it's now becoming a standard part of a family law practice in general. And so I think we all have to pay more attention to this, whether you're a mental health provider working in the family law community, whether you're a judge, a mediator, or a guardian, you're just going to see more and more of these cases. Now, as I indicated, many of these cases are going to involve significant complications because often there's a mental health issue, there's a chemical dependency issue, there's some kind of a breakdown of the family relationships in general that are driving these third-party custody cases. So if the law weren't complicated enough on these cases, you've also got that dynamic going on in the background with these families that are coming in on these cases. And so they're going to be more complicated because of those factors as well as the legal issues involved. Many of these issues would have previously been handled in juvenile courts. There would have been child protection cases involved. If a parent wasn't able to take care of a child, or if there was a grandparent coming in saying, gee, I'm concerned about what's going on with my grandchildren, or I need to be involved with my grandchildren because I'm an important part of this, there would often be some kind of a concern about how the family was functioning. And so many of these cases used to end up primarily in juvenile court child protection cases. Well, with dwindling resources happening all over in these kinds of cases, many of the parties can't get the services that the families need in juvenile court, and so they end up in family court in private cases where they're seeking some kind of a third-party custody arrangement. The other thing that I've seen in Minnesota, and I don't think this is probably unique to Minnesota, is that there have been an enormous influx of people from the immigrant communities that are coming in with these cases. That adds yet another layer of complication to these when you're dealing with other cultural practices on child rearing. Many cultures have a big emphasis on grandparents and relatives being involved as an extended family with the parenting and the child raising. Well, that culture may be different, and it may run headlong into what our legal requirements are and how these cases are handled from a legal standard. So that adds yet another complication to these cases. Now, I want to set the stage a little bit for the Troxel case. Dan talked about it because it clearly had an impact up here in Canada and elsewhere, but I can't overemphasize enough the impact that this case had in the United States in terms of family practice. Those of you who are from the United States and lawyers in the United States will appreciate this. Those of you who maybe are not lawyers or don't practice in the United States, this may not be as clear to you. But the way the system is set up in the United States, we have 51 jurisdictions when you count the District of Columbia. Family court is done primarily at the state court level. Over the years, there's been an increasing development of what we call the federalization of family law, where the United States federal government is getting more and more involved, but it's still by and large a state-governed area of law. And as a result of that, it's very rare when family cases get into the federal court system in particular and to the United States Supreme Court in particular. So you can probably, I've done a survey over the years of U.S. Supreme Court cases that are direct family law cases, and there's probably no more than 20 or 25 of those cases. And that's in an over 200-year history. So it's a pretty rare and it's a pretty big deal when the U.S. Supreme Court hears a family court case. Many of you may have been following this Indian Child Welfare Act case that the U.S. Supreme Court issued last summer. That was a big deal. That was not even specifically a family court case. It was an adoption case that had a federal statute involved. So that was a big deal. But Troxel, when it came down in 2000, was a huge deal for family law practitioners because here is our highest court in the United States weighing in on a very important family law issue, which happened to be third-party visitation in the context of a grandparent situation. Dan laid out the facts of the case, so I won't go back into that. But the case goes well beyond a visitation with grandparents. It goes on to all third-party practice. And so it kind of sets the stage for what we need to talk about here. In addition, I think the United States is probably, most of us who practice in the United States would agree to this, is we're a very litigious society in the sense that most disputes in the United States end up in court in some fashion or another. I think probably more so than even in Canada and in certainly the Commonwealth countries, I think in general. Most family court disputes, family law disputes, ultimately have to end up with a district court or a judicial decision of some sort. So these cases, by their very nature, are legal disputes. And I think we have to keep that in mind as we're looking at third-party issues. The thing that I think that makes a third-party dispute the most unique, and when you put it into the broader context of family law, is that there is a constitutional dimension. And again, this is more background as to why Troxel is so important in this area. Every law student in the United States will get through law school by having at least one semester, if not more, of constitutional law. You study the United States Constitution, what's in the Constitution, and what it means. Well, then you go off into practice, and most likely, unless you're a criminal defense lawyer, you're probably not going to talk much about the Constitution in your practice. But there is one area in family law where we do have to be aware of the Constitution, and that is these third-party custody cases. And that, again, is why the Troxel case was so important. Because it's an area where the Constitution has a dramatic impact on how we handle these cases. Well, so why is it that there's a constitutional issue in these cases? And here we have to do a little bit of history. In that Law Review article that I'm circulating to you, I put a lot of background information on the history of childhood, the history of custody, the history of how family law evolved over time, because I think in order to understand and have a good appreciation of Troxel and third-party custody, you need to understand historically how this came to evolve. And actually, there was no discussion of a parent's fundamental right, as we call it in the United States, under our United States Constitution, to parent a child until about the 1920s. And that was when we had a series of cases by the United States Supreme Court that began to look at these issues. They're kind of interesting cases because where they were coming into play, one of them had to do with the parent's right to pull a child out of school. And it had to do with, I believe, the Amish community, and they wanted to pull their children out of school in the 8th grade, and the state said, no, you have to keep your children in school. And so that issue went up to the U.S. Supreme Court, and that raised for the first time who gets to decide these kinds of issues about parenting. Well, if you think about it, there's kind of a three-way dynamic going on there. There's the parents who have an interest. There is the state that has an interest, and the state in these cases is usually the court. And then there's also the child, him or herself. How do you balance those three competing interests in these cases? That's the challenge in third-party cases. And in third-party cases, you've also got the third party coming in, then adding to the parent, the child, the third party, and then the state through the court. How are we going to figure out whose interests prevail? That's what makes these cases so challenging. And what Troxel says, and what this whole line of cases that developed a fundamental idea of a fundamental due process right for parents to control who has access to their children, all the parenting decisions that go with that, that's where it flows from. And the United States Supreme Court basically says that this is one of the oldest fundamental rights that's ever been articulated. And in fact, the language, I think Dan had this in one of his slides too, is that this came from Justice O'Connor's plurality decision, where she says perhaps it is the oldest of the fundamental liberty interests recognized by the United States Supreme Court. And I think what is sort of interesting is if you take a little bit of time to look at that case, and again, my article has a detailed discussion of which of the justices did what on it. It's sort of a microcosm of the disputes that still rage in this area of third-party custody and parenting time. We still haven't come to a consensus, I would argue, as to how these different interests get reconciled in these cases. And if you just tease apart that case for a minute and look at the makeup of the decisions, it's kind of interesting. Justice O'Connor wrote what we call a plurality decision. And it's a plurality because she had 4 justices agreed with her particular decision. And we have 9 justices on the U.S. Supreme Court, and in order to get a majority, you obviously need 5. And so on that, the plurality decision was made up of O'Connor, Ginsburg, Breyer, and Rehnquist. And they all, as Dan said, affirmed the state of Washington Supreme Court, which said the parents get to decide on this case. This is a case where we have to look to the parents, and the lower court erred when it looked at best interests and balanced that and treated everybody equal. In fact, that was wrong. The parents should have had a more superior right to determine what happened. So it was O'Connor and those other 3 justices who did that. Well, Justice Souter gave her a 5th vote, which is how the majority view prevailed in that case, but he didn't want to tie this to a constitutional due process right. He said it's just, we don't need to wade into the thicket of constitutional due process. And Clarence Thomas, interestingly enough, is a very staunch parental rights justice, and he basically said he would have applied an even stricter scrutiny and made it even more difficult for the parents' rights and interests to be disregarded. So he is counted as another vote, and so basically, if you count his vote, you've got the majority that you need. So what about these three dissenters on that case? Well, those three dissenters sort of illustrate nicely the other view of things that Dan alluded to in his presentation. Justice Scalia, not surprisingly, who is no fan of finding these due process rights in the Constitution, the penumbra theory, if any of you know about with the Roe versus Wade thing, he said this is nonsense. If it's not in the Constitution, it doesn't exist. This fundamental right of a parent is not in our Constitution. We shouldn't deal with that. But he doesn't say we don't have a right. He goes back to the Declaration of Independence. And he says parents have an inalienable right to raise their children, but it's not in the Constitution. So he's viewed as a dissenting vote and a no vote. But the other two, and these are the two that I sort of pick up when you read my article. The flavor of my article is I'm sort of an advocate for third parties' rights, primarily because of my adoption and assisted reproduction background, where I think biology should not necessarily be determining in when we set up custody and parenting time relations. But Justice Stevens and Justice Kennedy, both of whom are grandparents, I might add, came out very strongly dissenting from this and said, what about the best interests of the children in this case? These children have interests separate and apart from their parents, which in their opinion should be elevated above the rights of the parents. That should be our focus here, not these parents' fundamental due process rights to make all these decisions. So the fact that we had such a fractured, splintered Supreme Court issuing this decision on this majorly important area of family law practice is quite telling, I think, in the sense of we still don't have a good consensus in the United States, and it sounds like in Canada as well. When I was listening to Dan's talk about the different statutes here, people are still struggling with this. Whether you're dealing with a grandparent visitation situation, a third-party custody situation, any of those different things, it's not clear. It's always going to be a balancing test. The law of the land in the United States is the U.S. Supreme Court, which all of the states and all the state courts must apply, is that there is still a heavy preference for parental rights. Parents have that fundamental right to decide who has access to their children, under what terms and circumstances, and that's what needs to be followed. So let's move then beyond the Troxel case. You kind of get a flavor of what that's about. And how do we put this into practice? How does this work in our cases? The Troxel case caused a lot of academic discussion, a lot of legislative activity. I mentioned at the beginning we had a statute in Minnesota. Interestingly enough, there's a footnote in the Troxel case where they commented on some state statutes that were acceptable under their analysis. Minnesota's visitation statute was one of them that was named as an acceptable version because Minnesota has long had a statute that says in a grandparent visitation dispute, grandparents can have visitation as long as it's not going to disrupt the parent-child relationship. So that statute was viewed as putting a proper burden on a third-party grandparent to come in and affirmatively show that if they were to get visitation, it wouldn't harm the parent-child relationship. The Supreme Court said okay with that. Other statutes were not as clear, if they even had a statute, that didn't clearly parse out how these burdens would be apportioned, and many of the district court judges were left, trial court judges were left to try to sort this out, and many just simply applied a best interest analysis. Basically put the parents and the grandparents or the parents and the aunt and uncle on a level playing field, and the Supreme Court said, no, you can't do that. Parents are up here, third party is down here, and the task of the trial court is to analyze the case in a way that protects that right. And so a lot of statutes were revised after this. A lot of appellate decisions were challenged after this, where people who were unhappy with the third-party custody order said, he didn't follow Troxel, we need to review this. And so courts have had a bit of a challenge dealing with it, as have legislators. And again, some of this we've kind of covered in my discussion. But if I could sum up the way most of the laws and most of the cases and the statutes in the U.S. deal with this, there is in my outline a footnote. It's footnote number 2. And for those of you who are not familiar with it, it's a wonderful resource if you're ever having to do national research in the United States because of all the separate jurisdictions. They're called the ALRs, the American Law Reports. And what these are is they're a synthesis of all of the state case law across the country on various topics. And as I did my research for this, I was sort of amused to see, I'll read the topics of what these things are, and they're annotations around a topic, and it'll tell you the variety of disputes that come up. One of them is called Validity of Grandparent Visitation Statutes. Another is Child Custody and Visitation Rights Arising from Same-Sex Relationships. Grandparent Visitation Rights where children's parents are living. Grandparents' visitation rights where children's parents are deceased or where the status of parents is unspecified. Visitation rights of persons other than natural parents or grandparents. Awards of custody of a child where the contest is between a child's parents and grandparents. awards of custody where it's between grandparents and one other than the child's parent, and then award of child custody where contest is between a child's father and a grandparent. So you can have all sorts of permutations on these cases, but it still comes back to basically a showing under all of these statutes or cases that either the parent is unfit in some fashion, or the parent has abandoned the child in some fashion, or this is kind of a catch-all that sort of gives the court an out to get around some of these heavy burdens on the third party, a special need or circumstance for that child. So here is where you could sort of weave in arguments under these cases if the child has a very close bond with a grandparent, for example, and the biological parents are objecting to a grandparent having access or custody, one or the other. You could say that this child will be harmed because of either special needs, maybe the child has some behavioral issues or mental health issues or something, or some kind of a learning disability, for example. You could build a case around that to show that there's a special need or circumstance tied to the child rather than looking at the rights and interests of the parents and the third party. But typically you need to show one of those three, unfitness, abandonment, or special needs of a child, plus best interests of the child. So think of it as best interests of the child plus this added factor that flows from Troxel and the constitutional issue. Let's see. So burdens of proof, and we talk a lot about burdens of proof in these third-party custody cases because, again, it gets to this issue of who's got to carry their heavy burden of proof of getting over that constitutional mandate. Where do these cases arise? What's the sort of the context where you're going to see grandparent visitation or other third-party visitation or custody? Oftentimes they'll arise in the context of a death of a parent. That was certainly the case in the Washington facts that gave rise to Troxel. It's quite common that I see in my practice. Often it's a divorce situation where the one of the parents either doesn't get significant parenting time and it's having an impact on the grandparents having access, or the parents are estranged and as a result the grandparents become estranged. And there's limit, the one parent who's got primary custody doesn't like the other parent's grandparents, so they try to cut them off. Children born outside of marriage creates all sorts of issues because typically if that biological father doesn't step up and get adjudicated, the rights to his parents, the paternal grandparents, flow through his legal status. And so many times I will get paternal grandparents coming into my office and saying, we're devastated, we're not able to see our grandchildren, the mother won't let us, but our son never did anything. And so we often have to look closely at our statute to see that do they even have standing to bring an action? Because if their rights don't pre-exist based on the father's adjudication, they may have some trouble going forward. Other areas where we're seeing these are other relatives besides grandparents, and then it's not unusual to see step-parents. In a divorce situation, you may have a non-biological step-parent, the parents get divorced, and that stepfather or mother had a close relationship to the child, and that now the ex-spouse will no longer let them see the child. So we see some step-parents come in. They come under the same analysis. A step-parent would be looked at, too, just like a grandparent would in terms of the burdens of proof that need to occur. They're difficult cases because judges are often reluctant to add more complexity to an already difficult divorce situation. But those cases are out there. Same-sex couples and couples where the same-sex couple has split apart, we could spend the whole day talking about that whole topic and how it's impacted, but I see a lot of third-party custody arrangements and third-party visitation issues flowing out of those situations. Because as those of you who practice in the U.S. know, not a very small minority of states allow same-sex marriage. But same-sex couples are getting together, they're building families. Oftentimes they don't do the legal steps that are necessary to establish the legal parent-child relationship between each of the parties. The relationship splits up, and then the non-legal, non-biological parent is left without any rights to see that child that they've treated as a child. So they're coming in under third-party custody and visitation statutes, sometimes both. The other thing you should be mindful of is these third-party statutes often have different requirements for custody versus visitation. Just as an example, in Minnesota, we've got this sort of quirk in our statute where it's easier to establish standing to petition for custody than it is for visitation. Now, why would that be? It makes no logical sense. But it basically goes back to this idea that visitation can be very disruptive. So if you're going to have a right to bring a visitation statute, you have to have shown you lived with this child for 2 years. Well, many people can't meet that statutory criteria. I've had just devastatingly tragic same-sex couple cases where they separate after about 15 months of a relationship. They can't bring custody. There's no basis to bring a custody petition because there's no abandonment, there's no unfitness by the other parent, and the child has no special needs. So there's no basis for custody, and they don't meet the criteria for a visitation order. So they're just out of luck completely. So those cases are real challenging. Another area where you might see some of these issues arise is in juvenile court child protection situations, where one of the dispositions in those cases, if a child can't return home after there's been a child protection investigation and involvement, one of the dispositions is a transfer of custody to a relative, typically. And so that same analysis will oftentimes come into play in your child protection cases. The newest area where I'm seeing third-party issues come to the forefront is in a category of cases we have in the United States, and I don't know if this exists anywhere else. You maybe call it something else in other countries, but it's called special immigrant juvenile status. These are children who are in the United States. Typically, they're illegally under our immigration statutes, and they're on the verge of being deported because of that immigration status. And one of the things that immigration lawyers can do to help them out is get what we call an SIJS order. Well, to get one of those orders, they have to be under the protective supervision of a court. And in order to get in the door to get that kind of an order, you often have to bring a third-party custody action so that the person who's caring for this child can get an order that says, I can have this child in my care and custody. That then opens the door for the immigration piece of it. So that's a big area that we're seeing more and more of in the United States, where third-party issues come to the forefront. One of the things, and I'm not going to spend a lot of time on this because it goes a little far afield from what we want to talk about today, but when these cases come into my office, the most typical kind of a situation that I see is it's usually a relative of some sort, a grandparent or an aunt or an uncle, who's got a child that they're either having extended contact with or they're actually parenting and caretaking for that child. And they've got the biological parent who's coming in and out of the child's life, maybe telling them, if you don't, do this or do that, I'm going to take the child away and you're never going to see the child again. And so they're wanting to solidify that legal relationship with the child. And so what I will oftentimes do is begin a discussion of what I call the spectrum of options that are available, from the most limited, non-permanent to the most permanent. And it sort of gives you an idea of how these third-party custody and visitation sort of fit in on that spectrum. On the one end, the least restrictive are things that are like powers of attorney, estate planning, things that people will put together that would say, here's who can care for my child if something happens to me, a delegation of parental authority. They're pretty much voluntary arrangements that a parent will put in place that can be revoked at any time. On the other end of the spectrum, the most permanent is adoption or guardianship, where you're actually terminating the parental rights of that parent and creating a new parent-child relationship through law on either adoption, or you might do a guardianship provision in probate court if both parents are deceased. Those are permanent determinations there's lots of things you have to go through in order to get that, but that's the most permanent. These third-party custody arrangements fit right in the middle of all of this. They're not as informal as the powers of attorney kinds of things, and they're not as permanent as the adoption and guardianship. But they're out there, and I think it's important to keep that context in mind as you're dealing with these. Dan mentioned some of the issues about how the courts are handling these, and some of the biases that come into play, and the procedures that courts have grappled with. What I'm finding in my practice in the United States, and this is kind of a segue to Mindy's piece on this, is how the courts are handling these cases more and more frequently, is they're kind of creating a bifurcated process. If you bring a third-party custody or a third-party visitation action, the courts will often have a preliminary hearing where they want to look at the petition or the document that brought the case into court and analyze the factual assertions in your pleadings. If those factual assertions are deemed and accepted to be true, have you met the statutory criteria? Have you met a showing of some kind of endangerment or abandonment or special needs of the child? And if you have, then how do we go to the next phase on this? And typically in the United States, you have to have a trial on one of these cases if the parent continues to object. And it's often helpful for the courts to have some kind of an assessment, some kind of a study to see, well, what's going on with this family? There's a lot of stereotypes about how grandparents interact with children. Oftentimes that relationship is not the rosy relationship that we often think about. Oftentimes that relationship is like the vignette that we saw up on the screen, where the parents distrust the grandparents and they're unhappy with their involvement. Oftentimes when you've got these situations where you've got an abusive situation or severe mental health or chemical dependency issues with the parents, somebody needs to investigate that and figure out what's the dynamic, what are these children's bonds and attachments with all of the various caregivers in their lives. And so more and more courts, I think, as they're seeing more of these third-party cases, are applying some of the same evaluative processes that we've always seen in regular garden variety divorce cases to third-party custody. But what it does is I think it puts a special onus on the professionals that are involved in these cases, whether you're a guardian ad litem, whether you're a court services worker, whether you're a private custody evaluator, mental health evaluator, to understand this legal context that Dan and I have been talking about, because that's going to impact how you do your study if you're a custody evaluator. It's going to impact how you do your investigation if you're a guardian ad litem. It's a different situation from a dynamic standpoint than what you have in a dispute between two parents in a divorce or a paternity case. And so that was my primary goal in this presentation, was in giving those of you, not only if you're practicing as lawyers, but if you're in the other professions that serve our cases here, an appreciation for the unique legal issues that come to play in these cases and how that will affect the work that you do. And I think I'll just leave the rest of that because I've got a pretty detailed outline that covers some of the other issues that are relevant. So I'm going to turn it over to Mindy at this point.
Okay, we've just taken a stroll through the law library. But now we're leaving the law library and we're going into your offices where you sit with real people, some of them adults and some of them children. And the perspective of this presentation is through the lens of the child. And so what I want to talk about, many of you who have heard my presentations know I love reviewing research. There's no research here. This is all about the perspective of the child. So when you're sitting with your clients and you're thinking through cases, we're thinking about what's important to kids. So I want you all to think about your childhoods. And for how many of you sitting in this room did you have a tremendously significant relationship with an adult who was not a biological parent? A lot of people in this room. And so I just want you to take just 5 seconds to think about what your life would have been like if that person had been removed from your life. So would 2 or 3 people be willing to say what you think you would have missed out on if somebody had said, "Oh, I'm so sorry, but you can no longer see that person"? What would you have missed out on? Yes. Oh, Auntie Mame. Okay, so she would have missed out on adventure. I love that word. Yes. Okay, consistency and great times in the kitchen. 2 extraordinarily important things that are actually on my list. Yes. So she would have missed out on history, yes. So she would have missed out on all this cultural stuff, including something very important, which is speaking a different language. Yes. So this person also would have missed out on cultural things, but from her perspective, she would have not had the person who thought she was perfect. Yes.
Both of my grandmothers were deceased before I was born, but my godmother was also my mother's godmother. And so we had an intergenerational connection through this common individual, which was very rich for me.
Okay, and so now we have cross-generational carrying forward traditions. So those are some of the things that I want us to think about. Okay, so can you see this cartoon? This is our daughter, my son from my first marriage, John's daughter from his second marriage, and I've no idea who the one on the end is. So who are we talking about? Well, Gary actually gave you a very fine list of the kinds of people we're talking about, and I just want to review it quickly. So, of course, we're talking about grandparents, but sometimes we're talking about step-grandparents, right? Like there's no word for these people in our language. One of the things that we sometimes have are grandparents who get excluded from the child's life after they do something like have their grown child committed. A mental health commitment, a chemical dependency commitment. There's something that goes on that then when the adult child comes out of it, they sever the relationship with the child. We clearly are talking about step-parents. I did a custody evaluation after a tragic accident. We always use the word tragic in front of accident, except in one of my cases where the dad was an antisocial personality disorder. And it's just true, but when he was killed accidentally, nobody called it tragic. I'm being serious. But most of these are just these horrible tragedies. So dad and a sibling are killed in an accident. And the situation prior to that was that dad and his second wife and biological mother had joint legal, joint physical custody in practice, although not on paper. The child at issue in my case spent 50% of his time with his biological father and stepmother and siblings, 50% of the time over here. So now we have this tragedy, and mom are in court together. And I have to tell you that if this child did not call his stepmother by her first name instead of by mom, I would have thought she was the biological mother. It would have been I would have been positive, right, if I had just seen them in a room together interacting, that she was the biological mother. We have other relatives, for instance, cases where mom has lived with her sister and she's parenting a very young child, and again, something happens. I had a case where mom and dad, biological parents, were never married. Then mom marries, and then mom runs off to join the circus. And I don't mean that as a metaphor. And so who are we left with? Dad, who belonged to what he called a motorcycle group. Some of you may think of another G word okay. And then you have stepfather, and the only active involved person in this child's life is the stepfather. And this was in the 80s, and I made a radical recommendation in the 80s that stepfather get custody. And it was very clear that stepfather would keep father involved, but father would not keep stepfather involved. And stepfather wound up with custody under who knows what law, but some very smart judge did that. No, seriously. And then we have non-relatives. And so I also had the case where mom lived with her best friend. She developed brain cancer, and when it was detected, it was way too late. As some brain cancers are, this was one of those very fast, very malignant, untreatable cancers. They can do palliative care. And she certainly made it known She made a videotape. She wrote. She went to all of her friends and relatives to make sure that everybody knew that the best friend that she had lived with since college and who had been in this child's life since before birth, because this was the woman who went through the birthing classes with her. This was the person who was in the delivery room, because Dad was like just a no count, that she desperately wanted this woman to raise her child. And again, this was before our statute in Minnesota. The mom's best friend wound up with custody of this child. And I had the good fortune, every once in a while you get lucky, you get to follow a case over years. She came back to me a couple of times across the child's life at significant points. And, you know, every once in a while, Dad, who was an over-the-road trucker kind of person, would come be swinging back through town and want to see the kid. And this non-mom, but mom, didn't want to do anything that would like stir the pot or stir the hornet's nest. And so she would want to have this child see. But this child was terrified of this man. She was just terrified of this man because he wasn't child-focused at all. It was about my rights, right? It's about my child, you know, capital M, capital Y. Okay. So now what are we talking about? That's the who. Now what's the what? So just how many people in the room are not mental health folks? Okay, a large number. So that's why I'm going to talk about bonding and attachment. So bonding is what I do when you give me a baby. You give me a baby, you let me have the baby in my care for 4 days. I am totally in love with that baby. I am bonded to that baby. That baby is not attached to me. Attachment grows over time and through interaction. And so we have babies that are attached to mom, dad, grandma, nanny, right? I don't know about in your jurisdictions, but have you ever had a custody or parenting time case where you wanted the nanny to get custody? Right? Because the nanny was the true parental figure. So when we're thinking about bonding and attachment, if we're looking at this through the lens of the child, bonding and attachment are essential. Now, sometimes you have somebody that the child is not attached to, but is bonded with. And again, this is one of those so tragic cases where we have an infant under 2 years. Mom and dad are killed in a car accident. And now the litigation is between sister of the mother and sister of the father. Well, they're not attachment figures for this little girl. They become attachment figures depending on where the child is placed. And since one of the sets of new parental figures lived in the same town, this was a small town in Minnesota, they got temporary custody, and the other aunt and uncle lived in the Twin Cities. They were much more affluent. And so it was interesting to see how the two experts, I was one of the experts, how the other expert evaluated what was important in this case. And I was just struck by how she was impressed by their affluence. I couldn't have cared less about their affluence. Unless you live in poverty, the heart of the child is not about whether you can afford, fancy ice skating lessons. That's not the heart of the child. The heart of the child is whether you go ice skating with them. And interestingly enough, in the judge's analysis of the case, one of the things that he said was the parents chose to live in this small town within 8 blocks of their parents, and these other interveners are going to remove the child from all of that stuff that was important to the biological parents. And I thought, this is somebody who gets the heart of the child. What else is important? Well, significant responsibility in caregiving. If we think of this through the lens of a child, we're thinking about somebody who's familiar to them. It's not just changing diapers, although if it's a baby, changing diapers is kind of important. But it's the things about, for instance, the step-parent who got up in the night with the sick child. It's about the aunt who was always the backstop when the parent had to go to work and you had a sick child, and that's the person who stayed home. And so what we're thinking about is what did they do with and for the child. And so we're thinking about things like who's the person that read to the child at bedtime. And I've got step-parents who do much more of that stuff than the biological parent. Who's the one who always came to the school concert? Who's the one that was on the sidelines cheering at whatever sport the child was in? And then we have parents who act like parents. And by that, what I mean is, for instance, most states in the United States still don't allow same-sex marriage. And so we have lots of people living in same-sex arrangements, and they present themselves to the world as parents. Everybody knows that they're the parents to the child, and that's an important aspect because that's who that child knows goes to their school conferences. That's who that child knows when it's mommies and muffins at daycare, one of their two mommies comes. And so one of the things to think about is, from this child's perspective, are these parents parents? And then I recommend to you the Family Court Review by DeFonso and Stern from 2013 on this whole topic of grandparent and third-party access to kids. And I like the words they use: consistent, purposeful, nurturing behavior. They're consistently part of the child's life. This isn't, oh, on occasion, I'll babysit. This is, I want to be a parenting figure in this child's life, and it's nurturing. This is about the heart of the child. So let's talk about dimensions of parenting that are important to kids. And what I want you to think about is, in some of our cases, we have adults who are performing these things, and in others, we have to think about who's best capable of engaging in these things with kids. And so again, if we think about the mom and the stepmom in my case, the stepmother was so attuned to this child's needs. He was a kid who was on the cusp of being labeled ADHD. And in his bio mom's care, he really looked ADHD. He was all over the house, and he would go from topic to topic, and his attention span, he would go from one game to the next. And in the stepmom's care, by the way, when you walk in, there was a big star chart to help him do things like brush his teeth in the morning, get his backpack ready for school, brush his teeth at night, because what she emphasized with him was him being personally responsible for himself rather than her nagging. If any of you know anything about ADHD, oh my God, do you find yourself nagging if you're not careful? Because that's just what you do. How many times do I have to tell you? And what she showed me when I did the home visit, which was just so lovely, was this was a kid who was into stuff. So he was into Spider-Man, and he wanted to own everything Spider-Man, including the Spider-Man watch. And so she showed me a thermometer-like chart that she had created for him. And as he did chores around the house, she colored off how much he had earned toward his Spider-Man watch, as opposed to, again, him saying, when can I get my watch, when can I get my watch, when can I get my watch? And in fact, when I arrived for my home visit, the 8-year-old was in the basement vacuuming because he wanted to earn his money, right? This is somebody who's attuned. This is somebody who's competent. This is somebody who is participating. When I talked to the school, who was the parent who attended the school conferences after the father was deceased? Stepmom. I spoke to the teacher. Yeah, there was a day when mom stopped by, but no, she didn't receive any emails from mom. Yes, stepmom was in regular contact, because you won't be surprised after your father and your sibling abruptly pass away. You're sad, you're angry, you're confused. And if you are already a kid with limited attention span, this drains all of your attention. And then presence. Uncontroverted fact, when they had the visitation for the father and the sibling, everyone said that the person that the child went to was stepmom. Now, we understand it because biological mom is grieving the loss of her child. We understand that. But everybody agreed. I mean, stepmom's grieving the loss of her husband and her stepchild, who she had raised from the time he was a toddler, by the way. And so these are the dimensions of parenting that we want to think about. This is what matters to kids. I want this to matter to judges. I want this to matter to mediators. I want this to matter to custody evaluators. I want this to matter to us because this is the way life is lived. And I have siblings on here because we sometimes forget that step siblings are tremendously important to children. And if we draw a big X through a step parent and take them out of the child's life, we're not just taking away all that they bring to the child's life, but we're taking away the sibling relationships. And so when we're working with our clients, we want to be sure their head's in the room with the kid. Not my rights, not my authority, but about what is important to their children. So these are the things that kids think about. Who's cared for me? Who's going to care for me? Who cares about me? The little girl who was afraid of the dad, she never got a sense that he cared about her. It was always about, I'm coming to town and I want to take her to the zoo. Didn't matter if she didn't want to go to the zoo, right? Like it was his plan to take her to the zoo. Didn't matter if she had already been to the zoo, like, a week before. And so it was not anything that ever was tuned into her interests or her needs. The person that was raising her, because this was not a relative, would say things like, I think she would feel more comfortable if I came along for the first hour. And then I think once she feels comfortable, I'll just say, sweetie, have a good time and I'll see you tonight. Dad wouldn't allow it. And this was a person who wasn't engaged in any kind of alienation at all. And this was a person who, if she had been allowed to come along for the first hour, the next 6 would have gone much better. But because she wasn't allowed to come along for the first hour, it ended after 2 because the kid was distraught, right? Who do I care about? And then what will I miss if that person isn't in my life? And the stories that you told were all about what kinds of things do kids miss out on if we sever relationships because the law doesn't recognize them. Okay. Mom, when you need parenting help, do you call Grandma for tech support? I'd like that, right? Now, for those of us of a certain age, there are certain things we need tech support with, right? Right? Okay. So we want to consider, of course, if we allow third parties and grandparents to be regularly involved in the child's life after the request that they're making, is it going to disrupt the relationship with the parent? Like, are we clever enough to figure out a way to make it not disrupt it? Can't we mediate ways that it doesn't disrupt? Can't parenting coordination include grandparents? Can't it include step-parents? Can't it include non-married but parents? I think the answer is yes. Of course, as Gary said, as Dan said with that wonderful chart he had about all the different things that are going on in kids' lives, is it going to be that if grandparents have every other weekend, that the child isn't ever going to be on a sports team because grandparents live far enough away, they're 3 hours away, that now that child can't be on the sports team? Can we just think creatively about how they can be involved and the child can still play hockey, soccer, tennis, whatever it is? And then if we grant the request for this third-party grandparent access, is this going to mire the child's life in endless conflict? Just like it is sometimes between two parents? because it's going to be religious differences, it's going to be about rules, it's going to be about rituals, and there's going to be such extraordinary differences that we're going to have all of that undermining that the kids get exposed to, where they come back, Grandma says you blah, 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 blah. You know, like after a father's passed away, Grandma says you're spending all of Daddy's money. Is that good for kids? No more than it is with two parents. And so we really need to stop and think about that aspect. So I love this quote from Jennifer McIntosh that has nothing to do originally with this topic, but I love it. The parenting arrangement should not make the child's developmental job harder than it is. And I think that should apply to grandparents and step-parents and everyone else. Finally, how come Grandma can have blue hair but I can't? Thank you so much. Do you have questions for us? Yes, and say who the question's for. So the question is about what do you do when you don't have, I'll use the term in quotes, good grandparents, but you have what I'll use in quotes are bad grandparents. Well, in that case, you often have the law on your side. And again, if you're representing the bad grandparents, I think what you talk about is ways that they can set down the long simmering dispute with their child and look, from the child's lens, we don't want more people in a child's life that are going to be disruptive. And so what we want to do is to use some kind of interventions, parenting coordination, family therapy, that work at those problems and do education the same as we do with undermining, disruptive, alienating parents, to teach them about why that isn't good for children and to see whether they can change. And just as with everything else in the world, some of them can change and some of them can't. Sometimes you have one grandparent who gets with the program and like puts his hand over Grandma's mouth. No, I'm being serious, because Grandpa sees that this isn't going to go well if Grandma keeps fighting the fight with her daughter or her son. And so we use the same kinds of interventions we all know about to see if some movement is possible and therefore some benefit to the child rather than just negativity. So that's a sad story about a child who is in the middle of protracted litigation, and how many of us want that for any child, right? And then winds up taking her own life. A very sad story. Yes? Okay, so the issue is about sort of what to do when there's alienating dynamics, but it's extended family. And again, I would use the same tools that we already have, which is I would be working with Dad and his extended family in a therapeutic arrangement so that the kid stops seeing this, I call it, contagion. Like if you're alienated from Dad, then his parents and the children's cousins and the dog are all tainted as well, and start seeing them as who they are. And it depends on what techniques you use. I'm a big fan of showing children photographs of family events where the grandparents were present and the aunt and uncle was present and those kinds of things. Sometimes you don't have them because Mom would never let the kid go to an extended family event of Dad's. There's some marriages in which you marry into a family and out of your own. It's not alienation, but then if it moves into alienation, you really don't have relationships and memories that you can capitalize on, but sometimes you do. But I don't know how you accomplish these things without some kind of therapeutic intervention. Mediation is good for the arrangements that the adults work out, but not for the heart of the child.
And I think I would second what Mindy is saying about using that therapeutic model, because what I'm always struck by when we do these kinds of presentations on this topic is the great disconnect between the mental health custody evaluation piece and the law on these cases. I've had many of these cases where a judge will make beautiful findings along the lines that Mindy said, is that this aunt and uncle are that for all intents and purposes the parent. The father's only marginally bad, not awful. And so the judge will make best interest findings and then get reversed on appeal because he didn't give enough deference to the biological parent, even though everybody professionally looking at this says, well, this is where this kid ought to be. So I think it's critically important to work as lawyers who understand the statute and the standards that apply with the mental health people so that you can get a way to structure the analysis of the evaluation in a way that's going to build the pieces that need to be there for the case. And that's why I think having the parenting consultant or some kind of a mediation is the best way to handle these, because until our law better matches up with what the child development needs, these are going to be these awful difficult cases that go one way in court and go another way in the evaluation, and with these horrific outcomes.
I have to stop and let you go to lunch because it's 12 o'clock. We'll be up here for a couple minutes if you want to talk with us. Thank you so much for your attention.